Hello, everyone. Professor Cornish here. Welcome to our presentation today on Terry and Miranda. Now, today we're going to be talking about two key cases. Both were heard before the Supreme Court of the United States, or SCOTUS. And the first one is Miranda v. Arizona, which is a 1966 case. Most of you are probably familiar with Miranda because it established the Miranda warning. You've probably heard in various cop shows you've watched, crime shows, you have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you can't afford one, one will be provided to you at no cost. If you talk to me, you can stop talking to me at any time. So you're probably very familiar with Miranda, but we're also going to be talking about Terry v. Ohio, which is a 1968 case. Now, in Terry v. Ohio, it and other related rulings established what is a Terry stop or a stop and frisk. It's a form of investigative detention where if you see someone maybe doing something suspicious, like for example, there's been burglaries in a business area late at night, and you see someone late at night walking in that area, that normally there's not anybody in that area at that time. Law enforcement going, okay, there's normally not anybody around here at night, but there's someone there and there's been burglaries in this area. I need to go talk to them to see what the heck's up. Terry and other rulings establish the guidelines for those investigative stops, investigative detentions, stating what you can do and what you can't do when you're talking to that individual trying to figure out what's going on. So, in the presentation, we're going to be answering the question, when you actually do a Terry stop, do you have to Mirandize that person? Now, with Miranda v. Arizona, it brought together actually three constitutional amendments that pertain to criminal procedure, that pertain to the criminal justice system and how suspects, how they have their rights when they're going through the various stages of the system. So Miranda brought together the Fourth Amendment, which is protection against unreasonable search and seizure. And with Miranda, we're talking about seizures, arrests, or things that look like arrest. The Fifth Amendment, which we'll get into in a second, and the Sixth Amendment's right to counsel. That ruling brought all three of those amendments together. Now, the Fifth Amendment, it states an individual cannot be compelled in any criminal proceedings to be a witness against themselves. Now, this really means they can't be forced to self-incriminate. Self-incrimination, it's forcing a suspect to provide evidence against themselves. Now, this part of the Fifth Amendment is known as the self-incrimination clause. Now, initially, the clause only applied at trial, but Miranda and other rulings brought the self-incrimination clause protection to everything that happens before trial as well. So with those additional rulings, the Fifth Amendment, it's not just at trial, but it can apply to interrogations conducted by law enforcement and any confessions that result. Now, SCOTUS, as well as the lower federal courts, state courts, they recognize that coerced, meaning forced confections, are relatively untrustworthy. and violate the suspect's constitutional rights. Now, with Miranda v. Arizona, SCOTUS extended the Fifth Amendment protection against compelled self-incrimination, this individual being forced to give evidence against themselves to the interrogation process. Now, with Miranda, as I stated, not only do you have the protection against compelled self-incrimination in the interrogation process, it's also bringing in the Sixth Amendment's right to counsel. Miranda is one of the rulings that extended that right to counsel from trial to everything that can happen before trial. Now, Miranda requires that prior to law enforcement starting an interrogation, they have to notify the suspect of their constitutional rights. And that's a Miranda warning. You guys are probably very, very familiar with the Miranda warning, which we'll get into on the next slide. But the right to counsel, the reason why that right is granted in interrogations is to ensure, because interrogations, even when law enforcement does what they're supposed to in an interrogation, it can still be kind of coercive. It can be intimidating. If you've ever been questioned by law enforcement, like if you've been a witness or a victim, it can still be kind of intimidating at times. Like, oh my gosh, the cops are right here. Why are you guys here? Oh, it could be intimidating even when law enforcement's doing what they're supposed to. Now, think about it if you're a suspect, how that might be. So, the right to counsel, really, the reason why you can have an attorney during an interrogation is to make sure law enforcement is not using tactics that they're not supposed to, tactics that could violate your protection against compelled self-incrimination. And also the right to counsel, the reason why you have that in an interrogation is to make sure that if you do confess, it's voluntary, that you're not being forced to do it in any way. Now, the Miranda warning, and this is a pretty common version of the warning. Depending on the state, you might have some slight variation at times, but you have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you can't afford an attorney, one will be provided to you. If you decide to answer questions now without an attorney present, you will have the right to stop answering at any time until you talk to an attorney. Now, that part, there's going to be some variation. Some jurisdictions also have, if you choose to talk to me, you can stop talking to me at any time. And then an additional, do you understand these rights as I have read or stated them to you? And then with these rights in mind, do you wish to talk to me? That's pretty much the meat and potatoes of the Miranda warning. Again, there's going to be some variation depending upon the jurisdiction. But regardless, they have to have pretty much those elements. Now, since we've been talking about interrogations, you might be wondering, okay, she stated a lot of custodial interrogations. What is a custodial interrogation? Because SCOTUS has ruled in Miranda and other warnings and other rulings that the two triggers of Miranda, when the Miranda warning has to be given, a custodial situation and an interrogation. So what are those? Now, the first trigger of Miranda is custody. Now, custody occurs when an individual's freedom is under the actual and immediate control of an official or authority. Now, pretty much you're under the control of law enforcement if you can't voluntarily leave that situation. You're being forced to participate, meaning it doesn't matter if you don't want to participate or not, you're going to be, and you can't leave that situation. Now, the courts have determined an individual is taken into custody if they're deprived of their freedom of action in any significant way. Again, meaning you can't freely leave that situation. If you want to stop participating, you can't leave it. That's, or law enforcement is doing something that makes you feel you have to participate and you can't leave. And we'll go more into that later. Now, under these rulings, force, and this definition is way different than like uses of force, um, like takedowns, strikes, pressure points, using a baton or a taser or firearm. We're not talking about that kind of force here. Force in what we're going to be discussing is conduct used by law enforcement that intrudes on the person's privacy or freedom. So basically, we're talking about anything that makes the person feel they can't leave the situation, that they have to participate. That's what we're talking about with force here. So, way different than the definition of use of force. Now, Berkmer v. McCarty, which is a 1984 case, it established an objective test the courts have to use to determine if someone was subjected to restraints, force, and intimidation or intimidation comparable to a formal arrest. So in this ruling, they were looking at, okay, what's the definition of an arrest, which is custody. So they were looking at, okay, what can we actually define as custody? Now, the ruling focused on how a reasonable person would understand the situation if they were experiencing the same or similar circumstance. So, if the person was in the same situation, would they believe that they were under arrest, that they were in the custody of law enforcement and couldn't freely leave the situation? Now, a reasonable person, and I'm going to give the formal definition and then I'll kind of C-spot run the definition. It's an individual possessing an ordinary degree of reason, care, prudence, foresight, or intelligence whose conduct, conclusion, or expectation regarding a situation is used as an objective standard to measure or determine something. A reasonable person is your average Joe Blow citizen. Your average citizen, so we're not talking about law enforcement, or an attorney, a judge. We're not talking about anybody with specialized legal knowledge. We're talking about your regular citizen and how they would, if they were in the same situation or one that's similar, how they would view that situation. So that's what we're looking at when we're talking about a reasonable person. So if you've ever heard reasonable person or the reasonable person standard, we're looking at how an average citizen with regular knowledge, how they're going to view that situation and how they would feel if they were in the same or similar situation and how they would see it, what conclusions they would draw. Now, SCOTUS and the lower federal courts have determined that a reasonable person would consider themselves to be in the custody of law enforcement, meaning arrested, if in New York v. Quarles, they were surrounded by law enforcement and placed in handcuffs. Obviously, if you're surrounded by law enforcement and you're put in handcuffs, even if they do not say you're under arrest, you're going to pretty much think you're under arrest. And obviously, if you're surrounded by law enforcement and you're in handcuffs, you can't freely leave that situation. United States v. Purdue, it stated you're in custody if you're questioned at gunpoint. Obviously, if you're at gunpoint, because law enforcement has their firearms drawn on you, you're going to definitely feel, oh crap, yeah, I can't leave the situation or I'm going to be shot and I don't want to be shot, so I'm just going to stay. Now, other situations where the courts have ruled someone is in custody, if they're formally arrested, meaning law enforcement said you're under arrest, if they're confronted for an extended period of time. Now, if you're in like a traffic stop or an investigative detention, which we'll get into what that is later, that's only for a short period of time. Traffic stop is just long enough for them to run a check to make sure you're not, you don't have any active warrants, your license is valid, your vehicle's not stolen. They're going to write the ticket or give you the warning, send you on your way. Investigative detention, with that, they're just talking to you to figure out what the heck's up. And when they determine, okay, yeah, this person's good to go, you're going to leave, you're going to be leaving. So not so in both cases, not very long, but we're talking about extended periods. So we're talking about like over 10 to 20 minutes. Involuntary encounters where you're being forced into the situation, whether law enforcement stating you can't leave or they're doing something that makes you feel, oh crap, I can't leave. Especially if you're thinking, oh, if I try to leave, I'm gonna get force used on me. Encounters occurring in private locations where other people can't see. You're not free to leave the situation, whether law enforcement says you can't or they're doing something that makes you feel you can't. You're surrounded by law enforcement, um, restrained in handcuffs, placed in the police cruiser, you're held under gunpoint, etc. So anything that makes you feel you have to participate and you can't leave, whether you're told you can't or the actions strongly lead you to believe you can't. And again, they're going to be looking at how a reasonable person would view this. So, with the situation, everything that happened, would a reasonable person believe they're in custody? They can't leave, they have to participate. Now, the level of force and intimidation used by law enforcement in these circumstances, they restrict the individual's freedom of action, meaning their freedom to voluntarily participate in the situation and voluntarily leave to such a degree that a reasonable person would believe they're in custody. Now, that's the big thing with that is someone might, the reason why they use reasonable person in with this is somebody might go, oh yeah, I was arrested. They had me in custody. And then law enforcement didn't actually do anything that the courts have determined a person is in custody. So that's why they use a reasonable person standard is you might have somebody go, oh yeah, they had me in custody when law enforcement didn't actually do anything that would cause another person to believe they were in custody. So that's why they use that standard. They look at the circumstances of the situation and go, okay, given the situation, would another person also, if they were in the same or similar circumstance, believe they were under arrest? Would they come to the same conclusions as the individual we're mainly talking about? Now, California v. Vailor, an individual is not considered to be in custody, and Miranda writes, not triggered until the force or intimidation used by law enforcement is considered at the level of an arrest. So basically, with that, if law enforcement is not doing anything to make you feel you have to participate and you cannot leave that situation, they don't have to Mirandize you. So, like, for example, if law enforcement is interviewing you as a witness or as a victim, or let's say in the example I gave earlier, that person in the area late at night where there's been burglaries at businesses happening, that person's not in custody at that point. So law enforcement doesn't have to Mirandize them. But let's say law enforcement's talking to a victim. Let's say their garage was vandalized. And then the person, the law enforcement was talking to the victim, and then the victim goes, "Oh, yeah, and I assaulted the person." That's going to flip things where now it's, "Oh, hey, you just admitted you assaulted somebody." So at that point, things would flip. But if law enforcement isn't doing anything to make you feel that you have to participate and you can't leave the situation, you're not under arrest, so they don't have to Mirandize you. Now, the next part, interrogations. Now, we discussed the first trigger of Miranda, a custody situation. Now, okay, what is an interrogation? Because you might be like, oh, well, she's kind of talked about questioning and that they don't have to Mirandize. So, what's actually an interrogation? Now, the Miranda warning, again, it was designed specifically to counteract the inherently compelling and intimidating environment created during custodial interrogations. And really, with the Miranda warning, partly what they want to do is prior to Miranda, there was a huge problem with law enforcement using tactics they weren't supposed to. And they did have a lot of circumstances where people were false confessing, confessing when they didn't actually do anything. So with Miranda, partly the reason why SCOTUS did the ruling that they did is to create an environment where the suspect knows their rights and is free to invoke them if they desire. So, like if law enforcement is interrogating a suspect and the suspect goes, "I want a lawyer," law enforcement has to allow that person to contact a lawyer. And if they don't have one, they can't afford one, then it's okay, we're gonna contact the public defender. We're gonna look at that list and call somebody off of it. Or if you state, "I don't want to talk to you guys," you can't talk to them anymore about the crime or anything like that. Or if you're talking to them, they do talk to you and then they say, "I don't want to talk to you guys anymore." You've got to stop. Now, the Miranda warning is necessary before an interrogation happens. So again, what is an interrogation? Rhode Island v. Innis. SCOTUS explained that in interrogation, it does not merely refer to direct questioning of an individual. So this is why when if you're a witness and you're being questioned or a victim, law enforcement doesn't have to Mirandize you because they're just talking to you. And in like an investigative detention, like a Terry stop, for example, yeah, the person kind of the situation is suspicious, but they're just talking to the person at that point to figure out what's going on. So it's still just questioning. But what differentiates questioning from an interrogation is in an interrogation, It is law enforcement using any words or actions outside of those commonplace in like custodial or arrest situations where law enforcement should realize there's the high likelihood that person could incriminate themselves, give evidence against themselves. That's the difference. So even in like, let's say a person is being interrogated and they invoke their right to remain silent. Law enforcement can still, hey, are you thirsty? Do you need something to drink? Hey, are you hungry? They could still do regular chit chat. They just have to stop anything that could end up potentially causing that person to give evidence against themselves. There's the difference. So basically, in order for anything like questioning or other tactics to require a Miranda warning being given, law enforcement must possess the knowledge that allows them to reasonably anticipate that their tactics, what they're doing, what they're saying, has the likelihood that the person will respond in a way that they could end up giving evidence against themselves. There's the difference. So like going back to that example about the victim whose garage was vandalized. When law enforcement's initially talking to the person about the garage being vandalized, they don't have to Mirandize them. But the second the victim messed up and went like, oh yeah, and I beat him up. What? Now that person, they just admitted to a crime. And obviously, the next line of things from law enforcement are going to be, what do you mean? How did you insult them? What happened? Blah, blah, blah. Anything that law enforcement says after the person just confessed, there's a good chance that that victim, now suspect, is going to give evidence against themselves. So the second that person confessed, which they just did right out of the blue, law enforcement is going to have to go, whoa, whoa, okay. You have the right to remain silent. Anything you say can would be used against you at a court of trial. So there's the flip. So with Miranda, if you know that there's a high likelihood that person, the basically your line of questioning, if you know there's a high likelihood that person is going to say something that's going to be incriminating, going to be giving evidence against themselves, you've got to Mirandize. Now, Berkmer v. McCarty, anyone in custody, meaning they are not free to leave, and accused of a crime must be given the Miranda warning prior to being interrogated. So if you're in custody, meaning you're not free to leave that situation, and accused of the crime, meaning you're a suspect, law enforcement's pretty sure you did it, they have to Mirandize you. Now, Orozco v. Texas, incriminating statements made by suspects are invalid without prior warnings, even if the suspect is not in custody in police station. So this means that even if law enforcement's talking to you away from the police station and Miranda gets triggered, they have to Mirandize you. That covers. So it's not just in the police station. Again, going to the example of the vandalism. That interview could be at the victim's house. Most likely it would be at the house. The second the victim flipped and said, oh yeah, and I beat the guy up. even though they're not in at the police station. Law enforcement would still have to, anything after that, oh yeah, and I beat the guy up, they're going to have to Mirandize. So with this ruling, it doesn't matter where you are. And now that we've gone into really Miranda, now we're going to cover Terry stops. So we're going to finish answering the question first, what a Terry stop is, and then, hey, does Miranda actually apply to this? Now, Terry v. Ohio, again, 1968. Law enforcement observed Terry and another individual in front of a store. And they were acting kind of suspicious, like they were kind of casing the place. And that means they were kind of, when law enforcement was watching them, it looked like they were trying to, okay, what's this place got? Is there anything good in here? What are the locks like? How many people are working here? Where are all the good items at? So it looked like they were either planning a robbery or a burglary. So law enforcement going, huh, looks like they're casing the business. We need to check up on these two and figure out what the heck's going on. So law enforcement briefly stopped Terry and his buddy for questioning, just to figure out, hey, what are you guys doing here? Trying to answer the question, are they planning a robbery or a burglary? And they ended up doing a pat search of Terry and his buddy, which a pat search, it is a search of the outer portions of the clothing, using the hands. Law enforcement does pat searches, corrections use pat searches. You've also got private security that'll do pat searches as well. But with the pat search, you're trying to find, are there any weapons? Are there any like illegal items? But law enforcement, they ended up doing a pat search just to check and see if Terry and his buddy had any weapons. And they did it, okay, we want to make sure these guys don't have any weapons that they could potentially end up using on us while we're talking to them. Now, while conducting the pat search, the officers discovered both individuals had firearms. And the standard of proof that they used for this stop was reasonable suspicion. Based on how Terry and his buddy were acting, made it look like they were casing the place. Now, reasonable suspicion, it's more than just a hunch. It's objective and articulated with the specific facts of the situation that led to the suspicion of possible criminal activity and possible armament of the individual. Basically, what reasonable suspicion is, based on, like going back to Terry, based on the officer's training, knowledge, and experience, they were able to go, it looks like those guys are casing the business possibly for a robbery or a burglary. But what makes reasonable suspicion more than just a hunch is you've got to articulate it. You can't just go, oh yeah, I thought the guys were casing the business. Why did you think that? What were they doing that made you feel that way? So you've got to be able to write it down in any reports. You've got to, if it ends up going to trial, you've got to actually be able to explain it at trial. That's the difference between reasonable suspicion and a hunch. Reasonable suspicion based on the officer's training, knowledge, experience. And they have to be able to explain it. And they have to be able to explain it where a where another officer, and that's the reasonable officer standard, where another law enforcement officer would see it the same way. So, like in Terry, for example, if how the officers articulated what Terry and his buddy were doing, if they were able to articulate it, if another law enforcement officer went, okay, yeah, in that situation, I would definitely think that they were casing the place too. That's the reasonable officer standard. Now, US v. Cortez, SCOTUS stated that it's not enough to state you were trained and to recognize suspicious behavior that led to the stop, but you have to be able to articulate it. You have to explain the characteristics and actions that raised your suspicion. And again, you have to be able to write it out in reports. You have to be able to state it on the stand. And with this too, you do have that reasonable officer standard attached to it, where your regular Joe Blow officer, if they were in the same or similar situation, they'd see it the same way. So there is a version of the reasonable person standard that does apply to law enforcement as well. Now, some of you might be thinking, well, I've heard a lot about probable cause. Would probable cause actually apply to a Terry stop? No, the standard for Terry stops is reasonable suspicion. Now, probable cause, it's the minimum level of evidence needed to make an arrest or secure certain warrants. Based on the standard that requires a reasonable individual to believe that a person had committed a crime or criminal activity has or will take place. There's the difference. Reasonable suspicion is based on your training, your knowledge, your experience. You thought something was suspicious and you have to be able to articulate it in a report at trial where another person, given the same situation, would go, yeah, I'd go, too. I'd go check that out too. Where probable cause, it's needed for an arrest and or warrant, and the person and a reasonable person given that same situation would believe that a crime had been committed or criminal activity has or will take place. So there's the difference. Probable cause, you're going, oh yeah, crime definitely took place or it's about to happen, versus, huh, something's up there. They're kind of acting a little froggy, a little suspicious. There's a difference between the two. Now, under Terry, a Terry stop is considered a brief detention or stop. It's not a custodial situation. What it is an investigative detention. So you're not in custody at that point because you are still free to leave. It's not for an extended period of time. Law enforcement's not doing anything to make you feel that you're under arrest, but they're just with you just long enough to figure out, okay, are you actually up to something or are you not? But under the Terry ruling, SCOTUS viewed that these detentions are stops. And I know detention is kind of a confusing word with this because when you hear detention, you're like, oh, well, they're in custody. This is different. But they ruled that the stop and questioning was permissible despite the lack of probable cause for an arrest. So in Terry, they also said that, hey, reasonable suspicion is okay in this. Because, yeah, the person's kind of acting suspicious, or there might be suspicious circumstances, and you're just checking it out to see what's going on. They stated you don't have to have probable cause for that. You don't have to, oh, hey, high likelihood of crime that this person committed a crime or criminal activity has or will take place. SCOTUS stated in Terry, it doesn't have to be probable cause. That just checking, going, that's not right. Let's check this out to see what's going on. That's okay. Now, investigative detentions like Terry stops, made in the absence of probable cause, they are, and here's what an investigative detention is. They're brief, far less intrusive than an arrest, and less dominated by law enforcement. So brief, basically, you're free to leave the situation. They're just kind of checking things out, and you're free to go afterwards. So it's pretty much nearly the same thing as a traffic stop. You're being held just for a brief period of time until law enforcement kind of see what's going on, and then they'll let you go if everything's okay. And if it's not, like during the stop, they figure out, oh yeah, you were casing the business, or you've got weapons on you, then you will be under arrest. Now, in Terry, SCOTUS defined the difference between a stop dash investigative detention and an arrest or custodial situation. One's the duration. In order for it to be considered an investigative detention, like a Terry stop or something else, it has to be brief, just long enough for the officer to either confirm or reject their suspicions regarding the individual in the situation. So you either confirm that, oh, yeah, they were up to something, or, okay, hey, yeah, the guy was in the business area where there's been burglaries happening after hours, but the guy lives here, lives in the area, and they couldn't sleep. Okay, you're fine, you can go. Also, they're going to look at too whether law enforcement's actions were deemed threatening by the individual. They're also going to look at the location. Was it a public area or a private place? And whether, from an objective viewpoint, the person feels they were free to leave. Again, we're looking at the reasonable person standard. Would another individual, given the same situation, would they feel they were free to leave? Now, a Terry stop would be considered a custodial situation. Remember, with custodial situations, just remember the term, if it looks like a duck and quacks like a duck, it's a duck. If it if it looks like an arrest and you feel you're probably under arrest, it's an arrest. Whether law enforcement formally says you're under arrest or not. So the courts ruled with Terry stops, although they are not considered custodial situations, basically arrests, they would end up turning into a custodial situation if law enforcement exhibited any threatening behavior, if they displayed their weapons. You draw your weapons. Guess what? Custodial situation. It doesn't matter. Some physical touching or restraining in any form occurs. Now, this is beyond, with Terry stops, officers are allowed to conduct pat searches just to check for weapons. So with this, they're referring to any physical touching above a normal pat search, which in a Terry stop, the person can go, nah, I don't want you to pat search me. That's fine. They can refuse that. And in that case, you as the officer would go, okay, hey, that's fine. Hey, that's fine. Just, while we're talking, just so I know I'm safe and that you're not reaching for anything, can you just keep your hands visible for me? So the person can refuse the pat search, and the officer can go, hey, that's fine, just please keep your hands visible. So anything above a pat search. And also, language and tone used by officers indicates the request is compelled. So it's what you say and also how you say it. Like, because remember, Terry stops, they're voluntary. The person doesn't actually have to talk to you. And if you go, you have to talk to me, guess what? You just turn that into a custodial situation. Now, USV Strickler, law enforcement, this was another Terry stop that wasn't actually a Terry stop. But in this case, law enforcement, they did what they were not supposed to. When they surrounded the suspect's vehicle with their weapons drawn, ordered everybody inside the vehicle to get out, and directed them to raise their hands. Obviously, that situation, a reasonable person, if they were in their vehicle or their friend's vehicle, and law enforcement all surrounded the vehicle, weapons drawn, ordered everybody out, and said, hands up, they would definitely feel that they were under arrest. So in this case, the Ninth Circuit went, nope, that's not a Terry stop. You guys just arrested them. USV McLemore, 10th Circuit case. Again, a Terry stop. It ended up being elevated to a formal arrest when law enforcement had their weapons drawn, gave the subject directives, and told them, place your hands on the airplane. So they had their weapons drawn, put your hands on the plane. Obviously, that individual is going to go, oh crap, I'm under arrest. Because now it's with those, they have to participate in that situation. There's the fear that, oh crap, I'm going to get shot or have other force used on me. And now with that force, we're talking about the actual use of force, take down stun guns, batons, pressure points, firearms. Now, in Berkemore, SCOTUS ruled that Miranda warnings did not apply to Terry stops. So in Terry stops, if law enforcement is doing what they're supposed to in the stop, Miranda rights are not required to be read. And the reason why is if in a Terry stop and other investigative detentions, if law enforcement is doing what they're supposed to, which a Terry stop is just one form of investigative detention. There's rulings on the other types, but with investigative detentions, as long as law enforcement is doing what they're supposed to, they do not have to Mirandize that individual because they are free to leave that situation. Law enforcement is doing nothing to restrict them. Whether it's saying you can't leave, they're blocking the way, they put the person in handcuffs, put them in the squad car, whatever. Law enforcement is not doing anything to make the person feel that they can't leave. So there's no force, no intimidation used, and it's not reaching the point where the situation would be considered a custodial situation. So in Terry stops, as long as law enforcement is doing what they're supposed to do in that case, it is not a custodial situation. Law enforcement does not have to Mirandize the person. Now, In the stop, if law enforcement, when they're talking to the individual, goes ding, 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 I'm pretty sure you did a crime. They reach probable cause, or if the person starts talking and kind of starts self-incriminating, like kind of starts admitting they did the crime, or what they're saying leads law enforcement to go ding, 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 high likelihood you, now very high likelihood you did something. If it reaches the point where law enforcement goes suspect, they would have to Mirandize. So you do have Terry stops that will, depending upon what's going on in the situation, if law enforcement kind of gets their suspicions confirmed, it'll end up flipping into an arrest where you would end up having to Mirandize. So if with Terry stops, if the individual does not feel that they can refuse to answer questions and leave the situation, the stop would be considered under the Fourth Amendment a seizure, which you can seize persons. That's an arrest. That's a custodial situation. So, so that's one of the flip. So that's also where a Terry stop can flip. If the individual, because of what law enforcement is doing, if they feel they can't leave that situation, they're forced into it. And a reasonable person, given the same circumstances, would feel, I can't leave the situation. It's an arrest. Now, the federal courts have ruled that if a person's freedom of movement and liberty of movement is restricted beyond that of a Terry stop, the stop is an arrest. It elevated. Now, the stop due to the individual feeling they can't leave the situation, whether it's law enforcement said you can't leave, they're blocking the way, they've got weapons drawn, it could even be too, they're fiddling with their weapon. It could also be body language, tone, volume. If they're doing something that leads the person to feel they can't leave and have to participate, and a reasonable person given the same situation would also believe the same thing, then it's an arrest. So it could end up being an illegal arrest under Florida v. Royer, or throw into a custodial investigation, which is different under Donaway v. New York. Now, an arrest, you obviously have to have probable cause to be able to arrest. And that, again, as we talked about earlier, that's a lot higher than reasonable suspicion. Reasonable suspicion, it's basically an educated guess based on your knowledge, training, and experience. To where you go, huh, uh, that's suspicious. Probable cause, you have to believe the person committed a crime or criminal activity has or will occur. It is a higher standard. And if you don't have that and law enforcement did something and a Terry stop to flip it to a custodial situation, if they don't have probable cause for an arrest, that situation is illegal. Now, if the stop is considered a seizure and there isn't probable cause, that seizure, that custodial situation would be deemed unreasonable and in violation of the Fourth Amendment. So basically, in Terry stops, law enforcement does have to be mindful. You got to watch, you kind of need to watch your actions, watch what you're saying, how you're saying it. I'm sure some of you have seen in like crime shows, like Law and Order, for example. Oh, we could talk here, or we could talk at the station. That that statement could potentially be construed as as the person has to talk to law enforcement. So even that statement, be very mindful. I wouldn't even make that statement. I would avoid that one because there's a chance that person you're talking to could lead, oh, hey, I have to talk to law enforcement. I have to participate in this situation. And if other people, reasonable person would believe in that same situation, oh yeah, I would feel the same way that I would have to talk to law enforcement. Ding, it's no longer a Terry stop. So again, with Terry stops, they are voluntary. You are free. The subject has to feel they are free to participate in the stop and the questioning and that they could leave at any time. And if they don't, and a reasonable person given that same situation would feel that, oh, yeah, I too would feel that I would have to talk to law enforcement and that I would have to participate and I couldn't leave the situation. It's not a Terry stop. And you violated the Fourth Amendment as well as potentially the Fifth. Now, in McLemore, the 10th Circuit clarified that if the person's freedom of movement was restricted beyond a traditional stop and frisk, which that's another name for a Terry stop. The reason why they call it a stop and frisk is pat searches are allowed in those situations. Just for law enforcement. Well, and in these pat searches, law enforcement isn't necessarily looking for anything illegal. What they're looking for is, hey, do you got any weapons that you could potentially use against me? So that's why they call it a stop and frisk, which again, with the pat searches, the person can refuse it. Now, if you force the pat search, you you just you as law enforcement just flipped it into a custodial situation. So the person can refuse it. Law enforcement just have to say, okay, that's fine. I just need you to keep your hands visible for me, okay? And explain why you're doing it. Hey, I want to hey, is it okay if I pat search you just to make sure you don't have any weapons or anything that could hurt me? No, I don't want you to pat search me. Okay, that's fine. Well then just to make sure that you're not getting into your pockets pulling anything out, can you just keep your hands visible for me? That's what you do with that. But again, in Macklemore, the 10th Circuit clarified that if law enforcement is doing anything above what they're allowed to do with a Terry stop, if a reasonable person would feel that, like, for example, if law enforcement ends up kind of using force above, okay, hey, I'm just conducting a pat search. If they go above that and flip it into a custodial situation, especially if a reasonable person would view it that way. So that kind of clarifies that, hey, just because the individual might have viewed that they were under arrest, we need to look at it objectively and see would another person, a reasonable person, your average Joe, in that same situation, would they view it? But it also clarifies too that, hey, law enforcement, if you go above a pat search, you just flipped it from a Terry stop to a custodial situation. Now, the individual, if it gets flipped by the person not being feeling that they were free to leave, that they had to participate in the questioning. Law enforcement does anything intimidating. They use anything above a pat search. The person would be in custody. It would be under a custodial situation, meaning Miranda got triggered. So with a Terry stop, if it gets flipped up into a custodial situation, and to a level where anybody in that situation would feel they're under arrest, you have to give Miranda warning. Regular Terry stops, you don't, because they're not a custodial situation. So as long as you're not kind of starting to view that person as a suspect, you don't have to Mirandize them. Now, under the traditional use of Terry, as long as the force and restriction used by law enforcement is in the realm of a Terry stop. So basically, you're not doing anything above a pat search. The person is voluntarily participating. You're not doing anything to make them feel they have to. And they are free to leave at any time. They feel this. It is still a Terry stop. Therefore, that person's not in custody and Miranda's not required. But even in a regular Terry stop, law enforcement doing everything they're supposed to. And person's talking to you and you start going ding, 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 you're the person who's been burglarizing the businesses. Going back to the example, and you were about ready to do something naughty, like let's say they did the pat search and they found burglary tools on the person. Ding, 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 they have probable cause. It's not reasonable suspicion anymore. It's probable cause because guess what? They just found burglary tools. Now they have to Mirandize. So there's the flip. It's either if it gets flipped into a custodial situation or law enforcement, it's not just reasonable suspicion anymore. Huh, you might be up to something versus now it's probable cause where, yeah, you are definitely up to something. That's when they would have to Mirandize. So if it gets flipped up in either way, you got to Mirandize. But traditional Terry stops, you don't have to. Now, I hope you guys enjoyed the presentation. If you got any questions, comments, concerns, please feel free to get a hold of me. Again, thank you so very much and stay safe out there, you guys.